Tonight, being competent to stand trial is a major factor in determining if a case can move forward or not. If the defendant is competent, the trial then goes on. If not, the defendant cannot be convicted of the crime they're accused of. Our Quentin Smith, he speaks with legal experts about mental competence. So, Quentin, we've actually seen a recent experience of this.
That's right, Scott. Just a few weeks ago, a judge ruled that William Thomas Chisholm is competent to stand trial. Now, you may remember, Chisholm is accused of shooting and killing a Starkville optometrist just last year. Whenever a trial is set to begin, lawyers will request their clients be evaluated, and often the trial can hinge on those results.
Mental competence.
It's whether you are smart enough to understand the legal process, understand what you're accused of, understand you've got a lawyer, understand there's a judge and a jury.
It's something lawyers on both sides look at when a defendant is facing trial for a violent crime.
There are a lot of people that suffer from serious mental illnesses that impact their conduct and behavior, but doesn't rise to the level of making them incompetent.
To determine whether someone is competent to stand trial, District Attorney Scott Colomb says a request must be made for a mental evaluation. If that request is granted, the state hospital will then perform a series of tests on the defendant.
They ask them questions about what occurred, they research their backgrounds, their school records, there's formulas they have to make sure people aren't cheating on the test. So it's not an easy test to cheat on. It's not an easy test to cheat on.
Once that's complete, a judge will take a look at the results. If the accused is ruled competent, then the trial will proceed. But if not,
what happens if they're not competent to stand trial is they are usually the charges are dismissed and they are civilly committed.
A murder case in Starkville is highlighting this process. Late last month, a judge ruled Thomas Chisholm is in fact competent to stand trial for the death of Dr. Shauna Witt.
His lawyer requested a mental evaluation to determine whether he was competent, one, but also to determine whether he was eligible for the death penalty.
When the death penalty is in play, the court must also look into mental capabilities.
For example, the Supreme Court has said you cannot try a person for capital murder if their IQ is below a certain level.
This means that even though a person is competent to stand trial for the crime, they're not necessarily eligible for the death penalty.
The Supreme Court has made some higher rulings and a little more stringency to ensure that people that may not be capable of understanding the context of what they're doing are protected more so than a normal person who should understand what's going on.
Now, Colomb says one problem the state faces is there's not enough long-term treatment for people with a mental health illness. He says a lot of times the state hospital is not able to keep and treat people suffering from serious mental illnesses to the point where they are competent to be legally held responsible for their actions. Scott?
All right, Quentin, thank you very much.